she has sent the fee dispute to them, and she has sent the fee dispute by certified mail to Mr. Riccio's office as well. Now, in order to adjudicate a lien, we have to have some certain amount that is owed, and the perfected lien. Now that the lien has been perfected, it was delivered to her, etc. The some certain amount is what we don't have, because that requires by statute either an agreement by the parties as to what the amount actually owed is, or for the court to set, or for there to be a fee dispute resolved, setting forth what the reasonable amount of attorney's fees are. In order to set that reasonable amount, we, in this particular case especially, would have to have some kind of an evidentiary hearing on that issue. Because, first and foremost, that the motion that's in front of us today does not have enough information for a reasonable amount to be set forth. We don't have the billing statements in the motion. We don't have the Brunzell factors being addressed. And Mr. Riccio is not here to address those either. Further, in order for there to... the court in Argentina has specifically said that when there is a fee dispute, it would be improper for the court to summarily adjudicate those attorney's fees. Now, before we move forward with any kind of an evidentiary hearing on that issue, now, we would object to that on two bases. The first is this would not be the best forum for a fee dispute to be argued. We're in a situation where this case is clearly going to be moving forward on custodial issues. With addressing the fee dispute, it's very likely and very possible that we're going to have to be talking about attorney-client privileged information. Second, the contract between Ms. and Mr. Riccio specifically says if there is a fee dispute, it's going to be handled through arbitration. That's the contract. And we can be sure that if this was the other way around, and Ms. was saying, court, please, Your Honor, get me some of that money back because his fees were unreasonable, they would be asserting their rights under that contract, and it's a right under a contract. The arbitration clause is something that the Supreme Court has time and again said it's something that is enforceable. And so we're just asking that the parties either go through the Nevada Bar arbitration or through the American Arbitration Association as per the contract in order to settle that fee dispute. Once that fee dispute has been settled out, then the court can adjudicate the lien based on that resolution. But it wouldn't be appropriate for this court to address that, not summarily and not through an evidentiary hearing. It should be through the arbitration per the parties' agreement.
I can briefly respond to that.
Yes, go ahead.
Mr. Riccio perfected his attorney's lien on August 20th, provided monthly billing statements. There was never any contest prior to this about the amount during the course of his representation. Additionally, counsel brought up Argentina. Argentina has substantially been superseded by statute under 18015, which gives this court the authority to reduce to judgment a retaining lien and charging lien as appropriate. Counsel mentioned the possibility, again, of arbitration through the bar. This is now 4 months after the court first brought up that issue, and we still don't have a fee dispute filed. Consequently, Mr. Riccio filed his motion, which is supported by billing statements and by a calculation of interest pursuant to the fee agreement.
Yeah, I'm looking at the fee agreement. Contract requires that she dispute any billing after 10 days after receiving the billing statement.
And she did that. In fact, she disputed the fee with Mr. Riccio after receiving the billing statement through phone calls and emails. And as soon as the issue was filed with the court, she disputed that there as well. So the dispute regarding the fees has been ongoing. Now and like I said, she has tried to contact them, even continuing till just recently, and her emails have been getting rejected. So it's kind of a catch-22 for her.
They actually read them, so...
Okay. It's kind of a catch-22 because she has to try to resolve it before filing a fee dispute, but her emails are getting blocked, and, now she...
them certified mail.
And she sent them certified mail, and now, she has to file something. True.
Where is that?
Excuse me?
Where is her objection to the bills by certified mail?
Oh, no, Your Honor. The certified mail issue was more recent when she was letting them know that she's filing a complaint with a fee dispute. But it was filed with this court, her disputing the fees and the attorney's lien. As far as disputing the fees when she received those, there is nothing in the contract that says she has to dispute those by certified mail or by filing something with the court.
You made a representation that she has disputed them by email and by certified mail. So I'm asking you, where is the proof that she disputed it by email and certified mail?
No, Your Honor, that she has sent certified mail to them in regards to the fee dispute with the bar. I have proof of the rejected emails right here.
Do you have proof of the certified mail?
I believe as those with her. I didn't print those out.
Your Honor, if I can interject here for a second. I believe all of these rejected emails, if there were any that were rejected, were subsequent to perfection of the attorney's lien. There was no dispute, to my knowledge, raised during the course of the representation or when the fee billing statements were provided to the client.
And Your Honor, again, the contract doesn't require her to send them either by certified mail or in writing. She just has to dispute those, and she did dispute those, and that dispute has been known and true. She didn't file a fee dispute with the bar until now, but at the same time, they haven't filed a fee dispute with the bar either, and it cuts both ways as well,
Necessarily, because they perfected their lien.
Oh, they knew that there was a dispute about those fees, Your Honor, and the contract is very specific, and it requires those fee disputes to be resolved through the American Arbitration Association. And so, it's also their responsibility to ensure that they follow their own contract.
So what proof do you have that she sent them disputes about the bills?
I have the certified mail receipt here on Ms. Delaney's phone, if we can provide this to the court as well.
Certified mail receipt for what?
For the issue regarding the fee dispute with the bar.
That was 2 days ago.
Yes, Your Honor.
I'm not accepting that.
Okay.
He's followed the statute. He's perfected his lien. There was no timely dispute.
There was.
It's reduced. You have an attorney. Do not speak up. He's doing a fine job in representing you. I disagree with your analysis, and I'm reducing it to judgment pursuant to their contract.